But let me turn now to our next presenter, Chris Burnside. Chris is from Frost, Brown Todd in Louisville, Kentucky. He handles complex class actions, insurance coverage, bad faith, fraud, and fire cases. He began his practice with the firm in the Tort and Insurance Practice Group, and he has also chaired the firm's e-discovery litigation review group and was instrumental in starting the firm's information management and electronic discovery group. Chris has defended class action lawsuits involving construction products, insurance claims settlement software, and tax issues. Speaking today on what you are about to learn is a fascinating and, dare I say, electrifying topic, the TCPA. Please welcome Chris Burnside.
Good morning. I don't know if it's electrifying, but the TCPA is certainly one of the hottest, if not the hottest, areas of class litigation today. And it seems that you might even be able to call it litigation mayhem, consistent with our seminar title. And it seems to be at the choice of Congress, the FCC, and opportunistic plaintiffs' counsel. One of the reasons, or there's several reasons why that's true, but one thing is that the statute, if it applies, creates near strict liability. It also creates statutory damages in the amount of somewhere between $500 and $1,500, which is quite attractive because it gets rid of some of the standing issues that you face in data privacy litigation. Every case is almost always going to come down to whether or not there was consent to make the call in question and whether or not you used an auto dialer or an ATDS or a pre-recorded voice message. There are a whole lot of maybes in this area. The law is very much still in the development stage. The FCC is speaking on this all the time, and therefore there are no silver bullets. Now, as we go through this together, I think that you're going to fall into one of two kinds of people. One is you're going to be a little uneasy, and you're going to be the person that says, I know my company is doing something with text messaging, but maybe I better look at this a little closer. You also might fall in a separate category, which I'll call the excited category, and that's where Ellis and my wife ended up, because as I explained this to them, they said, oh, I know exactly what you're talking about. I got 2 of those calls yesterday. Who can we sue and how much can we recover? So whether or not this is a business issue for you, we've all had the calls. The history of this is the statute's about 20 years old. It's essentially a privacy statute. The focus is on automatic telephone dialing systems and pre-recorded calls. It's enforced in a variety of ways. There's a special emphasis on advertising and telemarketing, cell phone communications, consents, and opt-outs, and a lot of other things. One of the reasons it's gaining traction is some of the things really changed in a significant way in 2013. There's a broad HIPAA exemption, I hope I have time to talk about that a little bit, that came online in 2013. But the big change was that you have to have prior written consent in order to do advertising and telemarketing phone calls, both to cell phones and residential lines. And that took away a big defense that companies had when they called someone's home if there was an existing business relationship. The other really big change, in my view, is that if you do telemarketing advertising calls, that you have to have you have to have an opt-out. Now, these opt-outs are a little bit tedious, and you need to include them. But let me go forward just a bit. I want to give you 2 warnings about all this, and that's number one is if you're using an ATDS or a pre-recorded call to smartphones, it's risky. You can only do so for emergencies, and you can only do so if there's prior express consent. And a lot of people want to think this is a telemarketing statute. It's not, especially with cell phones. If you use an ATDS, you must have prior express consent, unless it's a advertising or marketing call, and then you have to have express written consent. The other piece is you've got to have opt-outs for all telemarketing calls. And those opt-outs are very tedious. The statute, there's a lot of things going on in this, and for a phone call, pre-recorded voice message, you have to have that opt-out in the first 2 seconds of the call. It's got to be interactive or key activated. And you also have to have the opt-outs for faxes. And for the fax piece, it's even more tedious. And the challenge here with the opt-outs is you might have consent and you might have done everything just correct, and you don't include an opt-out, and you've got a class action. And that's exactly what has happened in the Sixth Circuit for a business there. The district court did not certify the class under Dukes, and the Sixth Circuit did, saying you didn't address the fact that there was no opt-out. Now, these texts tend to be pretty simple, and the action really is in the texting and cell phone calls. And so this is from my bank. Thanks for opening your checking account. If you have any questions about services, give us a call. Oh, if you refer a customer to us, we'll give you $100. And then after a while, they say you're late on your payment and you pay up. So these have huge consequences, and they create a tension for business. The first consequence is big-time exposure, and that's regardless of whether there's real liability. So when I say it's a billion-dollar problem, we can see $107 million in that problem right here with Bank of America and Capital One. And the issues there were prior express consent and also written consent. Now, they probably had lots of defenses, but the challenge of dealing with those defenses in one instance of a class of estimated to be 20 million people, it was a business decision to settle these classes. So why does business do this? What's the tension? Why would you take this kind of risk? And the reason is because it works. The texting works. And so think of your children. For my kids, if I call them at college, I don't get a return call. If I text them, they respond. And it's the same sort of thing here. 99% of texts are read. They're read quickly. And for the emails, the data is only about a third of emails are read. And what you'll see is, I think your inbox probably supports that. So is there exposure for the text I just showed you? And generally what you're going to look at is who sent it, what was the manner it was sent, what's the content, who received it, what type of phone. So for this text, when they say, thanks for opening the account, is there a violation? Could be. The question becomes, did I give them prior express consent to text me on my cell phone? The provision of a cell phone number is becoming very important, and there's a lot of litigation on it. I'm going to rest on that a little bit later. But for here, I'd say if you don't want unwanted text messages to your cell phone, don't give them the number. And that's a challenge because 50% of us are using nothing but cell phones. So anyway, if you don't want it to happen, don't give them your number. So is this a advertising or telemarketing text? And I think it probably is. It's at least a dual-purpose text, meaning it's got a little information and a advertising or telemarketing component. Telemarketing is the initiation of a call in order to sell services. Advertising is essentially saying the services are available and talking about the quality. This last text is pretty clearly marketing, and they're asking for referrals. And so the question here is going to be, did I give them express written consent? And it's very specific under the regs today. And a lot of people aren't aware of the change to express written consent. And the statute's specific as to what that needs to include. It has to be in writing. It has to have the signature of the customer. You have to disclose you're going to use an ATDS or a pre-recorded voice message to sell your services and advertise. It has to be all clear and conspicuous. And so it's a big challenge for business to meet this. In fact, one bank asked me, does that mean we have to have signatures in different places and have a whole separate paragraph? And the answer is maybe. What does clear and conspicuous mean? So here's the one big challenge, and this is clearly not a telemarketing call. It is, Chris, you're a bum, pay up. And so does this violate the statute and the regulations? And it could. And this is where the providing of the cell phone is getting a lot of traction, a lot of cases on the topic. The FCC from at least 2009 has said the providing of a cell phone during the creation of a debt is an invitation to call, and therefore it's not in violation of the Act. Cases are split on this, and the most recent case, and perhaps the most important case lately, is in your materials. We wrote an article on it, but we also gave you the case. It's Moz versus Gulf Coast. And in that case, the wife of a patient gave a cell phone number. Eventually, the insurance company didn't pay, and a debt collector started texting the husband. And the question was providing the cell phone number express consent? The lower court said no. FCC had exceeded its authority. The 11th Circuit said no, you can't do that, district court. The FCC is entitled to Chevron deference, and therefore it's not your ruling is inappropriate, we reverse. I want to pause here, and this Chevron deference deals with, has the FCC exceeded its authority? And there's several areas where the FCC is speaking right now, and the answer might be yes. For example, for an ATDS, the FCC has said that all predictive dialers without human intervention will qualify as an ATDS. That may not be true, and courts aren't following it. So that's an example. Unlike the 11th Circuit, other circuits have said in that area, no, that's advisory, FCC exceeded its authority. So here the question is, when they apply the exemption for healthcare messages, is it appropriate? Now, the other subtext of this is this marketing, because they care about my teeth, so that's healthcare, but they also want some money for cleaning my teeth, and so is that a sale of services? If they're entitled to the exemption, it probably doesn't matter. If they're not entitled to the exemption, it matters a lot, and it might come under the Best Buy case, where Best Buy sent out a text to loyalty customers, say, hey, come on in, your points are running out, and we've got things available. Well, the court said there that's dual purpose. You did give them information, good information, but it was an encouragement to come in and spend money. So that text violated the statute for Best Buy. So here, I think there's going to be litigation on the HIPAA exemption under the Chevron deference point. And I'll show you some of the tediousness of Chevron deference as well as the regs. Congress has said that the FCC can create certain exemptions. If you notice here in red, the rule that says that is applying to residential lines. Congress also says what's prohibited. And in that the section prohibiting certain conduct, it says unless the FCC has entered exceptions. Well, again, it applies to residential lines. When the FCC came out with the rule changes and recommendations in 2012, they got it right. It says we exempt from TCPA requirements pre-recorded calls to residential lines. Under the regulation, though, that came online, they applied it to cell phones. So just as you read it, it would appear that there could be some traction here. I don't believe there's any litigation on this yet, but it will be interesting to see what courts do with that for healthcare providers. So that dealt mostly with consent just now. The really fundamental question is, are you using an ATDS? Are you using a pre-recorded device, message? An ATDS is equipment that has the capacity to store or produce telephone numbers to be called using a random or sequential number generator and to dial such numbers. Early on, people didn't think, at least I don't think, they thought there would be a lot of litigation on what is an ATS because they didn't think there'd be much success with it. That's starting to change. There's starting to be some success. And in fact, one court has said the FCC's determination that a predictive caller without human intervention qualifies as an ATS is going too far. So I'm going to leave you with sort of a few interesting questions or points. The first is that phone sitting on your table. Is it an ATDS? People are starting to ask that question. And the FCC recently wrote a letter into a court saying it's not. We don't believe that it is. And that's what everybody wants the case to be, but I'm not sure it's quite so clear because when one of my clients asked me that question, I began looking at it and think, I know people are talking about that, but really? Well, there's these things called apps, and we all have them on our phone, and you can download an app, I learned, and I don't have one, but it will generate lists of numbers for you, and it will send out messages to 500 people at a time. And so if you have a sales force of marketing people who are selling services and they have those apps and they have customer lists, I might want to explore that a little bit to see, is it going to be considered an ATDS? I think ultimately no, but I don't think the answer is quite as clear as we would want it to be. The next point, if you're in the uneasy category, you're thinking, okay, well, we use third parties to do advertising, telemarketing, debt collection, and other things, and so can I be liable for the texts and the phone calls that they make? Well, the FCC said no, that the statute doesn't create direct liability for you, but there is federal common law agency, and so you could have liability. Now, this creates a real tension for business. The litigation exposure is huge. And so do you want to sort of manage your third parties? Do you want to look at those contracts and have ways to make sure they really are in compliance? Or do you want to keep them at a distance so that you can, no agency here, no exposure. And there's a case in the Ninth Circuit called Gomez, which is also in your materials, and they talk about this agency issue, and in that case, there was not an agency relationship that the court found under federal law. This is getting a little confusing because for faxes, the FCC recently said in a ruling that for faxes, there can be direct exposure even if you're using a third party. The distinction probably doesn't make a whole lot of sense, but the FCC can do what they want to do. So if you're in the uneasy category, you're probably also thinking, well, I got insurance for this. Well, under traditional policies, CGL policy, maybe. The question's going to become under coverage B of your CGL policy, are you in a jurisdiction that recognizes a cause of action for invasion of privacy because of the invasion of the right to seclusion, getting an unwanted text or call? If that's the case, you might have some coverage. The next question, though, is going to deal with this statutory damages. Is that a penalty? Is it a fine that would take you out of coverage? Or is it going to be treated as a more traditional damage and it's just the measure of the damage caused, and therefore you get some coverage? There are cases on this out there. Some courts have found some coverage. A lot have said no. Then there's cyber insurance. And so if you're in the data area, you may be looking at cyber insurance. You will not get coverage for TCPA violations. The risk is way too high. The numbers are way too big. If you're a big enough company, you might get an endorsement with some limitations on it. But in my conversation with Marsh and other brokers, it's really not out there. So it's very difficult to insure. If you're in the uneasy category and you become the sued category of defendants, then you might want to consider very quickly, and it's surprising to me how much traction this is getting because of the Genesis Healthcare decision by the Supreme Court. But you might consider sending Chris an offer of judgment for $6,000. Remember, there were 4 texts. That's the max. You probably want to add in the offer of judgment, costs and some other things. And now you have mooted my claim, arguably. And more importantly, you may have mooted the class claim. And in Florida, that's pretty clear. You're going to get a lot of traction. In the Ninth Circuit, and you can again read the Gomez decision in your materials, no chance. Offer of judgment is not going to work. But in those jurisdictions where it does, or in those jurisdictions where the courts haven't spoken, it could be a good strategy. You might end up with a new class representative somewhere down the road, but it's probably worth trying. So I'll leave you with a thought. I don't know which category you fall in. I was at a bank presentation, and we were talking about all sorts of statutes and acronyms. So I'll leave you with this. If you decide to use an ATDS, you might be in violation of the TCPA, the FDCPA, the CFBP, the UDAAP, which means that the FCC, FTC, FDIC, and not to mention the FBI and CIA, might be interested in what you're doing. So as a result, you may want to hire JD, a CPA, and a PhD so that you can deal with this litigation mayhem. I hope you really enjoy. And so I hope you enjoy the rest of your day here at GDM. Bye.